Let's jump right into some statistics here about special needs. If your loved one has a disability or special needs, you're probably not alone. You're definitely not alone. But the U.S. Census Bureau says 13% of U.S. residents report having some form of disability. And so that includes 4.8% of persons under age 18, 11% of persons ages 18 to 64, and 33% of persons age 65 and over. So that's pretty heavy odds. Far greater than the odds of you having your house burned down, maybe even of having a car accident. And so you have to be aware and be prepared, which is sometimes taken for granted when it comes to disability, whether it's you're born with it or developed early or strikes later in life. And another revealing statistic is 1 in 36 of American children are on the autism spectrum disorder. And it seems to be a growing stat as our culture has evolved, and what can contribute to those disorders is still being researched, yet still there's no denying that it's on the rise. And special needs can be present also not just at birth, but from an accident. It's not always something just developed genetically or otherwise. But basically, overall, not just the children, but you have to remember 1 in 9 Americans age 65 or older have Alzheimer's, dementia, which are Alzheimer's and dementia are closely related. Research is improving on that, on how to mitigate or even avoid, but it's still, the numbers are climbing. So let's just get a little bit more into what does special needs planning really mean. It's basically the process of providing for personal financial security and the well-being of a loved one. So depending on the circumstances, planning for special needs can be done by the individual alone or by the individual's loved ones, or the family can work together with the individual to make plans and make sure that their needs and interests are being met as much as realistically possible, if they can speak for themselves. And we can talk about the importance of who actually implements the plan a little bit better later. But for now, let's talk about who may be a candidate for special planning. So again, child of any age, maybe a sibling, spouse, or parent, or more distant relative or friend. Some people, the only family they have is actually friends. So the goals of special needs planning are essentially to balance your present and future needs and the future needs of your loved one, to create and implement plans that meet your loved one's personal care needs, as well as his or her financial and legal needs, and communicate those plans to all persons involved with the care of your loved one. That's key, communication, always. You want to review these plans on occasion and revise them as circumstances change, and assure family members that your loved one's needs have been adequately addressed. To help understand the specific steps you may need to take care or meet these goals as well. Oops, I jumped ahead accidentally. We want to take a closer look at how we can plan ahead. But now, by not planning for what might happen after you're gone, you may be risking your loved one's future. So certainly do what you can while you can to help others in your family. For example, if a guardian or conservator is needed to attend your loved one's personal or financial needs, and you have not planned properly, the court can appoint someone upon request who may not be the person that you would choose or that your loved one would choose. Or if you fail to provide for your loved one by executing a valid will, state law will determine how much property your loved one will get, and that might not be enough. Even worse, if you fail to plan ahead, there may not be enough money for the proper care of your loved one for the rest of his or her life. So it is vital that you put financial plans in place to make sure that this does not happen. So what are some of the specific things you need to do? Step by step, and we'll take a look at each one of these a little bit more in detail. You need to create and implement a personal care plan for your loved one. Create a transition plan for the continued personal care of your loved one as circumstances change. Create and execute a legal plan and a financial plan. Sounds like a lot, but it doesn't have to be too complicated. Now, a personal care plan involves thinking and making decisions about the kind of personal care your loved one needs. Some of those key considerations might be who will provide the care your loved one needs, and perhaps you can do it alone, or perhaps you can share the duties with other family members and friends. But if more care is needed, you'll probably have to consider getting professional help, like a full or part-time personal assistant, a therapist, or a nurse. You also need to decide where your loved one will live. Hopefully he or she can live independently, but if not, your loved one might have to live with you or another family member or friend. Or perhaps an assisted living arrangement might be necessary. And finally, you need to think about what kind of care is needed. So does your loved one simply need to get help with household chores and other daily tasks like buying groceries and paying bills? Or does your loved one need more help with things like getting washed and dressed? What about preparing meals? Maybe a meal delivery service might be helpful. Does your loved one need help getting around? Or can you or another family member or friend provide a ride? Or do you need to hire a driver or arrange for other transportation services? What are your loved one's medical needs? Can you make sure that medications and injections are administered properly, or do you need to hire someone to do so, or provide other medical care? And do you need special equipment like a walker, wheelchair, training equipment, and the like? And don't forget about safety issues. Make sure you have safety features such as ramps and rails installed in the home where your loved one will live. And you might even consider an alarm service. Also, you'll want to have a plan in place in case of an emergency. I happen to have a client who has been developing dementia, and they just had to move out of their house for 2 months to have it remodeled for these safety features. Fortunately, they had the funds to do so. Otherwise, it can take longer to afford and start making those changes, or just ideally move into a home when you're getting older that has those things already built in. Anything can help. If staying at home is your primary goal. Now, your second step concerns the creation of a transition plan for the personal care of your loved one. Let me just make sure we're still all together here. No problems with audio or visual. Okay. So the goal of the transition plan is to ensure the continuity of your loved one's care and supervision. And really an extension of the personal care plan we just talked about. This part of the planning process deals with choosing alternate people and services best able to help or replace those in the original plan if they are unable or unwilling to perform. You should try to anticipate and prepare for future life events that could affect you or your loved one. For example, if you are the primary caregiver, who would take over if you were to die unexpectedly? Or if your loved one ever becomes unable to make medical or financial decisions on his or her own, who will make those decisions on his or her behalf? You want to ensure your plan is carried out and to put some legal force behind it, which means executing some important legal documents. So these may include medical directives, so your loved one's wishes regarding important future medical decisions about his or her own care will be respected. So sometimes they're also called advanced medical directives, which can include a living will, do not resuscitate orders, and also healthcare power of attorney. Those are usually bundled into what you call an advanced medical directive or just medical directive. There's also durable powers of attorney, which authorize someone to handle your loved one's financial matters when needed. And usually durable means that it still allows your agents to act for you even when you are disabled. Some of them they don't. And so it's only when you can speak for yourself are they allowed to act for you. So that way you are knowing what they're doing for you and you're basically delegating things to them. So there's a difference. Or there's some that they're called springing and they only come into force when you are disabled and at no other time. So you want to make sure you have the right kind. You work with an attorney to make sure you have the one that's best for your needs. And of course, you want your last will and testament in which you can name a guardian who will continue caring for your loved one after you're gone. You can also use your will to provide financial support for your loved one's future, but be sure to coordinate the provisions with other financial plans that have been made or will be made. Maybe there's a trust involved, and so you want that will to coordinate with the trust. And remember, financial accounts often have their own named beneficiaries that they may bypass a will or a trust completely. So that's a lot more what I deal with the investment accounts for financial plans. Now, a letter of intent or instruction that's not legally binding can also be very helpful. Maybe you've seen in past presentations the family love letter, that's what it's dubbed, which is a letter of instruction, a non-legal document that provides additional insights on your life and your wishes, and also just the location of documents and say passwords to get into accounts and maybe the combination for your safe, whatever it is that they need to be able to get those important things when you are unable to do that yourself. You can even put your personal values, even your funeral plans, conveniently into a letter of instruction, if that's what you would like. And then make sure people have it so they know where to find it so they can use it. Now, to accomplish any of these things, again, you should hire an experienced estate planning attorney, or better yet, a special needs planning attorney. They're going to specialize in certain documents to make sure, and we'll talk about this a little bit more, that the person with special needs can still get government benefits, even if they might inherit other assets and other considerations there. There are some documents you can create on your own without involving an attorney per se. There's a lot more online services now that make it pretty easy. Just kind of plug things in and you fill out a template and it works for your needs. But you want to be careful, especially if it's a complicated situation or if you're just not comfortable. Yeah, an attorney will cost more, but at least you can know it's typically being done right and thoroughly. Now, the step 4 in the process ultimately entails creating and implementing that financial plan that would be tailored to help pay for your loved one's current and future needs. So for most people, planning ahead financially includes saving for retirement, saving for a child's education, providing for a spouse or children in the event of a parent's untimely death, like life insurance. But when you have a loved one with special needs, you also have a number of additional factors to consider, such as how much money is needed for the special care of your loved one. While that's not an easy question to answer, you can begin by estimating how much it costs on a monthly basis. And there are surveys available. Genworth.com has surveys, if you get on their website, of what it costs for care in your specific zip code on average. You also want to project the cost of your loved one's expected lifespan. So again, that's kind of tough to estimate, but you can get an insight based on family history, the longevity of ancestors, parents, and current health considerations can give you an idea of what's a realistic lifespan without, obviously you don't want to be pessimistic, but you want to be realistic with some hope, and then probably assume they might be living longer than you would expect, just in case, because that can be costly too to come short. Inflation, we've just gone through an inflation bubble, just about back where we want it to be, but it's kind of being stubborn. We're not quite there yet. Fed's working it out. That's affecting investments to some extent and whatnot. But inflation could end up bubbling up again, right? And so you want to factor that in. But the global average of inflation, if you look at the longest history, has been around 2.5%. And I know the Fed's trying to get to 2%. Which may be easier said than done. But that is a factor, especially if you're younger. You definitely have to factor in inflation that can get out of hand, especially for healthcare costs, which sometimes run above inflation. In many cases, they do. And websites, like I said, genworth.com can give you those. You can factor in inflation estimates as well. So once you've calculated the amount needed, you can then address this question. And again, this is something the financial planner can help you do, or we have software that can help you project it. But how will you be able to provide enough money for your loved ones while trying to fund your other goals? And that gets into more in-depth financial planning, but you do what you can to cover at least the known costs and the predicted costs of that care. So one of your first evaluations should be insurance. So health, disability, long-term care insurance policies that cover your loved one. It can offset many, if not all, of the costs associated with their care. A life insurance policy on your life can provide resources in addition to any funds that may come from your estate. So for the unknowns or the what ifs, or to replace income that was expected for years to come. And we already mentioned how important your last will and testament is, because you can use it to name a guardian. But this may also be the primary way your assets will get distributed to your beneficiaries, including your special loved ones. More especially if you had accounts and you didn't ever name beneficiaries on them. That can happen if it's just an individually owned account or even a jointly owned account, and you both have passed on the owners, that you don't name. It's notorious with bank accounts because they don't always encourage you to name a beneficiary on your bank account. And that's usually the first account people want to go to. And they get frozen once they learn that somebody's incapacitated or passed on. And then it becomes a real headache to get them unfrozen, let alone getting to the investment accounts if they don't have named beneficiaries. And then probate, and yeah, we want to avoid those delays. So government benefits, I mentioned that earlier. You want to make sure you can preserve those benefits if they're eligible, right? We've been paying the taxes. Now let's use them for the right reasons, right? To help out people who are eligible for government benefits. And in order to be eligible, the applicant can't exceed certain minimum income and asset levels. And that can be tough because you have to be basically at the poverty level to receive these benefits. And that would be sad to lose them because they can be substantial, especially over the years. So an important part of your special needs planning should focus on legally ensuring that your loved one is eligible to receive available government benefits, even when they have access to other assets from that they may have inherited. But let's take a look at some of the public benefits that your loved one may be receiving or may be eligible to receive now or in the future. There's national organizations, your community organizations, state aid, and the federal government. There's too many to list, so we're just going to generally categorize them. But let's take a look more specifically at a few, mainly from the federal government. That's going to be Medicare. Most people have heard of Medicare. And they are not necessarily needs-based Medicare. That's really a federal health insurance program for people 65 years of age or older, certain younger people with disabilities, and people with end-stage renal disease or kidney disease. There's also Social Security Disability Income, which is a program financed with Social Security taxes that are paid by workers, employers, and self-employed persons. Disability benefits are payable to disabled workers, disabled widows or widowers, or adults disabled since childhood who are eligible for Social Security benefits. And again, they are not need-based. In other words, you can get them regardless of your financial holdings. It comes down to qualifying by age or by disability, but it has to be very significant disability. There are other federal benefits that are available as well, such as assistance for special education expenses. We want to research them all, but too much to cover today. Now, here are the federal benefits that are need-based. Medicaid, which is actually a joint federal and state program that helps with medical costs for some people with low incomes and limited resources. Medicaid programs vary from state to state, but most healthcare costs are covered if you qualify for both Medicaid and Medicare. People with Medicaid may get covered for things like nursing home care and outpatient prescription drugs that are not covered by Medicare. And in some states, they have different names. Like in California, it's Medi-Cal, because they have some more unique rules. Supplemental Social Security Income Program, SSI, provides monthly income to people age 65 or older, or who are blind or disabled, and who have limited income and financial resources. So someone can be eligible for SSI even if he or she never contributed to Social Security. But it's a very minimal amount. But enough, sometimes it can make a difference for people. There are other need-based federal benefits, such as housing assistance. But again, we can't talk about all of them here. Just know there are more programs, and you want to research each of them in your state that are available. Now, there are special planning techniques. Federal and state laws permit certain planning techniques that maximize the use of all available resources, both private and governmental, to provide fully for the needs of individuals with disabilities. And for persons of limited means, government programs may constitute the primary, if not the only, source of funding for their current and future needs. Now, government assistance may also be available to families who have plenty of resources to meet their level of basic needs if they plan properly. So utilizing legal planning techniques, the individual is able to first tap into any government benefits to which he or she is entitled, allowing families to use personal resources to provide for non-basic needs. So in this way, the family's personal resources serve as a secondary source for additional support and comfort. So we'll take a look at those planning techniques in a little more detail. One of the most important planning techniques involves the use of a special needs trust, sometimes also called supplemental needs trust. And either way, SNT covers it. Special needs trusts were given official legal status by Congress in 1993. Typically, a trust is considered an available asset whenever someone applies for a means-tested public assistance program, such as Medicaid or SSI. A special needs trust, however, is an exception to this general rule. Assets in a properly drafted and administered special needs trust are not counted as available assets, and trust disbursements are generally not counted as income under the rules that apply to SSI and Medicaid. This is what makes a special needs trust such a valuable planning tool for someone with a disability, though there are costs and expenses associated with the creation of trusts. So there are types of SNTs as well. A self-settled or first-party SNT, which is sometimes called a payback SNT, a pooled SNT, and a third-party SNT. So we'll look at each type one at a time. A self-settled or first-party SNT is a trust created for the sole benefit of an individual with a disability who is under age 65 at the time the trust is created. The trust must be established by the individual's parent, grandparent, legal guardian, court, or by the individual with a disability who has capacity to do so. The trust is funded with the assets of the individual with a disability. For example, the trust could be funded with money that has been inherited or received in settlement of a lawsuit, or as a result of a divorce. And so, how do you benefit from a self-settled or first-party SNT? So we've already said that to qualify for Medicaid or SSI, the individual who is enrolling must have a limited amount of income and resources. Generally, Medicaid and SSI will look back 60 months to see if assets have been transferred to someone else in order to qualify for benefits. They call it a look-back period. And if so, the individual who is enrolling is disqualified from receiving benefits for a certain amount of time. Transferring assets to an SNT, however, does not trigger these look-back provisions. So, unfortunately, it's basically called Medicaid fraud. It's a big deal trying to hide assets when you've, for all intents and purposes, it should have been available to you, so you didn't have to tap into welfare. The other benefit, of course, is that assets in the trust will not be countable as resources for eligibility purposes. So using a proper special needs trust where the money is only going to be used for that person's needs can help protect it from being counted. The one disadvantage, however, is that upon the individual's death, any money or assets remaining in the trust must be used to reimburse the government for Medicaid benefits extended to the individual during his or her lifetime. So, yeah, it's kind of give and take system, but then whatever's left still can go to family. But just in case there's additional things the government can't provide, it can still come out of that special needs trust and still get those other benefits. So you can still end up with more overall, even if it was paid back, and allow those other assets to grow instead of being spent down. Now, a pooled SNT is a trust that is managed by a nonprofit organization. So funds are pooled for investment purposes, but separate subaccounts are maintained for each beneficiary. A pooled SNT works the same way as a self-settled or first-party SNT, and any funds remaining in the account upon the individual's death can be used to pay back Medicaid, or they can remain in the pooled SNT to help others in the pool, depending on that state's specific law. And then a third-party SNT is a trust created by the parent of an individual with a disability or other third party, but this type of SNT has no payback requirement. The person establishing the trust must not have a duty to support the individual, so the individual must be age 21 or older, depending on your state's law. There is no requirement that the beneficiary with a disability be under the age of 65, though. However, transfers to a poorly drafted third-party SNT may trigger ineligibility for Medicaid and SSI. And again, it depends on your state's laws. So that kind of, you don't have to pay it back because, yeah, there's lower risk that you're going to pay yourself unfairly. There's too much fraud. So that's why they have these rules. Another planning tool available is an ABLE account, a tax advantage savings vehicle that is similar in some respects to a 529 college savings account. An ABLE account can be opened by or on behalf of an individual with a significant disability. And if the disability began before age 26. The individual must be entitled to Social Security disability insurance or Supplemental Security Income benefits based on blindness or disability, or obtain a disability certification from a physician. If you or a loved one has a disability, you know that public benefits such as SSI and Medicaid can provide much needed support, but to remain eligible for these benefits, individuals with disabilities can have only $2,000 in assets, which is not enough to pay for most disability-related expenses. ABLE accounts help address this problem because funds in an ABLE account will generally not count toward the personal asset limit for SSI and Medicaid. Individuals with disabilities have the opportunity to save and invest for their future needs without sacrificing their eligibility for these benefits. All right, and then like 529 plans for college savings, ABLE programs are operated by states. Most states have already opened programs while others are in the process of implementing them. So most states will open their plans to residents of any state, so you'll have multiple options, even if your state is not offering one. Program details vary, and each plan will offer various fee structures and investment options. So you want to compare carefully before choosing one, maybe with the help of an advisor. So let's take a look at some of the basics, though. First, eligible individuals may only have one ABLE account at a time. And contributions can be made by anyone, including the beneficiary, family members, and friends. Contributions are made with after-tax dollars, and any earnings accumulate tax-deferred. In addition, distributions are tax-free when used to pay for qualified expenses, and they may include various expenses related to living with a disability, such as housing, healthcare, transportation, assistive technology, job training, and personal care. How much can you contribute to an ABLE account? The total annual contribution from all sources is generally limited to the federal gift tax exclusion, which is $18,000 in 2024. ABLE account owners who work to contribute more, if they are not participating in their employer's retirement plan, account owners may save an additional $14,580 from their earnings in 2024. All right, so it can be a very handy tool. Also, there's no federal income tax deduction available, but some states may offer an income tax deduction or other tax incentive to residents. State tax benefits should be considered when choosing an ABLE program. ABLE account owners who contribute to their own ABLE account may now be eligible to claim the retirement savings contributions tax credit when they file their tax returns, also known as the Saver's Credit. This non-refundable tax credit helps low and moderate income taxpayers put money away for retirement. They must meet all eligibility requirements for the credit, including age and income limits. And funds from a 529 college savings account may be now rolled over to an ABLE account without incurring taxes or penalties if certain requirements are met. Funds rolled over are still subject to the annual contribution limit that applies to all contributions combined. The ABLE beneficiary must be the 529 account beneficiary as well, or a family member of the 529 account beneficiary. All sorts of fun rules. And although ABLE accounts are a useful tool to save for the needs of an individual with a disability, they do have drawbacks. One potential and significant drawback is that upon the death of a beneficiary, funds remaining in the account may be subject to a reimbursement claim by state Medicaid program. Although outstanding expenses may be paid before this happens. So now that ABLE accounts are available, you might wonder whether an ABLE account should take the place of a special needs trust in your overall plan. And of course, the answer is that the purpose of both is really the same, to supplement but not supplant income and benefits from other sources. So both may be potentially suiting your needs. You need to explore the advantages and disadvantages of each, taking into consideration your goals and circumstances. So a special needs attorney can probably help you a lot. An advisor like myself can help you sort things out as well. You just want to make sure that you have the right fit for you or your loved one's needs. Okay, so let's see what else here. I think we covered that. Conclusion. So if you have a loved one who has a disability or special needs, questions you should be asking: are you concerned about his or her future potential needs and financial security? And are you concerned about meeting both your loved one's needs and your own? And if the answer to either of those questions is yes, some of these strategies may be helpful. And I'm always happy to follow up and discuss that with you or with friends who may be interested. You're welcome to forward resources from this that you can request. So, opportunity for any questions. Finished a little bit earlier